Order. The clerk will now proceed to read the orders of the day.
Item 1, Insolvency, Restructuring and Dissolution Amendment Bill, second reading.
Minister for Law.
Mr. Speaker, I beg to move that the bill be now read a second time. Sir, Singapore's insolvency and debt restructuring laws have undergone a multi-phase reform process over the years to ensure that we have both a progressive as well as a modern insolvency framework. Before 2016, it was not mandatory to appoint a private trustee to administer bankruptcy cases as the trustee in bankruptcy. And as a result, private trustees were seldom appointed, and the official assignee, or the OA, was appointed to act as a trustee in over 99% of bankruptcies. As part of MinLaw's ongoing review of the bankruptcy administration regime in Singapore, in 2016, the government introduced two key initiatives. First, a requirement for institutional creditors, or ICs, making bankruptcy applications to apply for private trustees in bankruptcy, which I will call PTIBs, to be appointed as a trustee administering the bankruptcy instead of the OA. Second, a differentiated discharge framework was introduced. This served to streamline the work processes and also create a more rehabilitative discharge process with clear time frames and conditions for bankrupts to be discharged. Sir, these changes have helped to streamline and improve the quality of bankruptcy administration, whilst at the same time ensuring that public resources can be better utilized. As of end of 2021, PTIBs administer about 40% of bankruptcy cases, with the OA administering the remaining 60%. Based on feedback that we have gathered from the industry, the experience of PTIBs undertaking the administration of bankruptcy cases that are filed by ICs have generally been smooth. This bill will now seek to introduce changes to the bankruptcy regime to mandate that PTIBs now administer all bankruptcy cases, except those which the OA will decide to administer, having regard to public interest. To support the shift towards a fully PTIB-administered bankruptcy regime, the bill introduces an amendment to improve operational flexibility in determining PTIB's remuneration. Finally, the bill also contains miscellaneous amendments that seek to enhance protection of persons dealing with bankrupts in commercial transactions and also extend the Simplified Insolvency Program, or SIP, for a further 2 years. Let me now elaborate on the key amendments in this bill. Private debt recovery lies at the heart of bankruptcy administration. Bankruptcy typically involves the creditor seeking redress for non-payment of a debt or a debtor seeking relief from overwhelming debts. A PTIB-administered bankruptcy regime aims to reduce the usage of public resources involved in private debt recovery, whilst ensuring that bankruptcy cases in Singapore continue to be managed in an orderly manner. Sir, there are precedents for such a practice from overseas. For instance, in jurisdictions like the US and Canada, the law mandates the appointment of the equivalent of PTIBs for every bankruptcy case in those jurisdictions. Clause 2 of the bill therefore amends sections 36(1) and 36(2) of the IRDA to mandate the appointment of PTIBs to act as trustees in all bankruptcy cases, save for cases where the OA consents to be appointed as a trustee in bankruptcy. Moving forward, the OA will provide consent only in cases where the OA considers there to be a public interest in the bankruptcy administration. Let me give some examples of such public interest cases. Typically, they will include cases where public finances are affected, such as, for instance, cases involving the misuse of public funds or where there are debts owed to government. These are not meant to be exhaustive illustrations. However, I would add that this does not mean that the OA will consent to act as a trustee in every case where there might be elements of public interest. The OA will continue to retain the discretion as to whether to take up these cases, and the OA will consider whether the public interest element is sufficiently compelling vis-à-vis other considerations, giving the appropriate weight to each of these factors before deciding whether to give consent. To complement these amendments, Clause 6 introduces a new Section 318 A to provide that a court must not make a bankruptcy order if a PTIB or the OA has not consented to act as a trustee in bankruptcy. Sir, together, these amendments will result in a shift towards a fully PTIB-administered bankruptcy regime. With this new regime, the OA will take on a more regulatory role to ensure the PTIB's competencies and legislative compliance in bankruptcy administration. Statutory duties, such as the powers of investigation as well as that of prosecution, will continue to reside with the OA. We have assessed at present that there is sufficient capacity in the PTIB industry to take on the additional cases following these changes. In other words, we made an assessment as to what the likely caseload will be after these changes, looked at the amount of resources in the industry, and our assessment is that there's sufficient capacity in the PTIB industry. My ministry has engaged industry stakeholders on these proposals, and the stakeholders include insolvency practitioners who are eligible to handle but are not yet currently handling bankruptcy administration. The Ministry of Law will continue to engage the industry to keep them abreast of the developments and provide the necessary support that might be required for them to take on this role. So the bill also provides support to the PTIB industry by improving operational flexibility for determining PTIB's remuneration. Currently, Section 41(1) of the IRDA states that a trustee's remuneration must be approved in the following manner. First, by agreement between the trustees and the creditors' committee. If there's no such agreement, or if there's no creditors' committee, remuneration has to be determined by a special resolution of creditors at a meeting convened by the trustee. Where there is no determination under either of the previous two modes, then the court has to determine the PTIB's remuneration. In our consultation with industry players, they have pointed out that they face obstacles in forming a creditors' committee for many cases. This includes unsuccessful attempts at convening a creditors' meeting to vote on the trustee's remuneration. There's also a lack of response from creditors on some cases. Those were the feedback that we received from industry players. This, in turn, has resulted in extra costs being incurred in bankruptcy administration, as the PTIBs will have to appoint solicitors to apply to court to approve their remuneration. This, in turn, reduces the amount left available for distribution to creditors, as costs and expenses of administration are given priority in the distribution of a bankrupt's property. So therefore, sir, to simplify the process for determining PTIB's remuneration and to keep the cost of bankruptcy administration low, Clause 3 amends Section 41(1) and inserts new subsections 1b, subsection 2 and 4 to provide for an additional means of determining PTIB's remuneration via an agreement between the PTIB and all the creditors. The creditors will be deemed to have agreed if they have not objected to the remuneration sought by the PTIB in the prescribed manner and within the prescribed time. I would stress that the creditor's right to object to such remuneration will be preserved, and if indeed the creditors do object, the PTIBs will still have to secure either a special resolution at a creditors' meeting or they'll have to go to court for approval. These amendments will help PTIB's fees remain affordable by keeping the costs down even as they take on more cases, and also seek to improve returns for creditors. Let me now touch on other amendments in this bill. First, the enhancement of protection of persons dealing with bankrupts in commercial transactions. Apart from amendments that allow changes to the current bankruptcy regime, this bill will also introduce measures to better protect persons dealing with bankrupts in commercial transactions. These amendments address concerns where members of the public were not aware that they were dealing with a bankrupt person, especially when large sums of money are involved. These measures will be introduced via two amendments. First, Clause 10 introduces a new Section 412, subsection 1D, which makes it an offence for an undischarged bankrupt to receive a deposit of at least $10,000 from any such person if he or she, the bankrupt, does not disclose his or her bankruptcy status to that person. This will complement existing Section 1A, which makes it an offence for a bankrupt to obtain credit without first disclosing his bankruptcy status. For this amendment, what do we mean by the taking of a deposit? What is a deposit in this case? In the amendment, when we say deposit, it refers to an advance payment for the supply of goods or services. This can be in the form of money or other in-kind consideration. Let me illustrate. A bankrupt who is an employee of a renovation company collects a deposit of $10,000 from a customer who has engaged the company to perform renovation works. The bankrupt, in this case, will have to disclose his bankruptcy status at the time he receives the $10,000, even though he might have been authorized by the company to collect deposits. Clause 10 also includes language which makes it immaterial whether the individual receives the deposit in his or her own account or on the account of another person. So in the context of my example, the employee receiving it on the account of the company will also be obliged to make this disclosure. It is also immaterial whether the deposit is received as full or partial payment. So whilst we set up these mechanisms for protection, we recognize that there also might be circumstances where this new offense might unduly inconvenience some bankrupts performing certain job roles, where they may have to receive and handle deposits of large sums on a frequent or day-to-day basis. Hence, Clause 10 also provides that the Minister for Law may exempt any person or class of persons from this new offense by order in the Gazette. Next, Clause 11 will amend Section 433, subsection 1 to allow the public to obtain information that undischarged bankrupts have submitted to the OA regarding their current employment status and employment history. This allows the public to conduct better due diligence when transacting with persons who are undischarged bankrupts. Such information will be available along with other such existing information in the Register of Bankrupts that is already publicly searchable upon the payment of the prescribed search fee. These two amendments will also apply and be enforced against bankrupts whose bankruptcy orders were made under the repealed Bankruptcy Act by way of Clause 12 of the bill. Finally, let me move on to the final set of amendments within this bill. And the final set deals with amendments which seek to extend the validity period of the Simplified Insolvency Program, or SIP, for an additional 2 years to 28 January 2026. So as members might recall, the SIP was introduced on 29th of January 2021 to help eligible micro and small companies, or we call them MSCs, facing financial difficulties due to the COVID-19 pandemic. This was part of the government's response to COVID-19 and comprised temporary insolvency processes which help eligible MSCs by restructuring the debts of viable companies to rehabilitate the businesses or, in some cases, to wind up the company where the business has ceased to be viable. These processes are meant to be simpler, faster, and low cost in nature, to optimize resources and potentially maximize returns to creditors. As at 31st December 2022, the official receiver has completed the liquidation of 27 companies under the SIP. Under the normal compulsory liquidation processes, the average time taken to complete the liquidation of such a company would take roughly 3 to 4 years. In comparison, liquidations under the SIP have been completed with an average of 6 months from the date the case has been accepted into the SIP. The validity period of the SIP lasts for only 3 years presently, so clauses 4 and 5 thus amends Section 72 capital B1 and 250 capital B1, extending the validity period for an additional 2 years to January 2026. These amendments will allow my ministry to provide continued support for such MSCs, which may face operational challenges, particularly in the context of the current economic environment of rising inflation and interest rates. In the meantime, I would add that my ministry is also reviewing the SIP with a view to making certain features permanent. For example, my ministry is looking at allowing insolvency practitioners, and not just the official as receiver, to adopt some of the SIP's simplified and expedited processes for the restructuring or winding up of eligible companies that are under their administration. This would in turn benefit more MSCs moving forward. Sir, in conclusion, this bill will ensure better utilization of public resources in bankruptcy administration, support the PTIB industry and MSCs, and also enhance protection of persons dealing with bankrupts in commercial transactions. With that, Mr. Speaker, I beg to move.